We are delighted to welcome you to the second part of our two-part webinar series, which provides an overview of key construction and adjudication cases of 2016. In today's webinar, we will be highlighting the key facts and legal points of each case that we're looking at, identifying specific lessons to be aware of for challenging or enforcing adjudication decisions. Both of our webinars from this current series are recorded and are available on our Vimeo site if you couldn't join us live or would like to listen again or share with colleagues. Now, just before we begin, to minimise background noise, I've placed you all on mute. If you would like to ask any questions, please do so using the webinar chat function, and if time allows, we'll answer those questions at the end. Now, I'm Ian Drummond, a partner in the Construction and Special Projects team in Sheffield and Wedderburn, and I specialise in construction and engineering disputes. I'm based in Edinburgh, and I'm joined by Nathaniel Buckingham, a solicitor in my team. As a team, we regularly advise in construction contract issues and disputes across a range of projects and clients. We therefore have a great deal of experience working in court and adjudication and arbitration, where our arguments have to fall in line with ever-evolving judicial approaches to adjudications and different approaches by other decision makers. And all of this experience helps us to form the basis of our strategic advice and what we are going to share with you today. I'm now going to pass you over to Nathaniel, who will take us through the agenda for this webinar.
Thanks, Ian. We will look today at the top 5 adjudication cases of last year, and for each we will provide a summary of the factual background along with an analysis of the key facts and legal points, whilst trying to draw out some lessons that can be learned and from which we hope can be considered and applied in your future contracts and claims. So I'll just quickly run through the cases we're going to look at. The first is Deluxe Art Theme Limited against Beck Interiors, which decided that one adjudicator involved in multiple disputes cannot adjudicate on more than one set of proceedings simultaneously without all of the parties' consent. The second is Sterlite Construction Limited against Croft Contractors, which confirmed that the court will rarely interfere with a decision unless the adjudicator has breached natural justice rules or exceeded his jurisdiction. The third case is Lulu Construction Limited against Mullally, which involved the recoverability of adjudication costs. The fourth is AMD Environmental Limited against Cumberland Construction Company, which covers the need for a crystallised dispute at the time of the notice of adjudication. And then our final case is John Siskins' son against Eurobuild, which considers whether an adjudicator can engage a third party in assisting to make a decision.
Whilst these cases, as with the construction cases discussed in our last webinar, are all English, much of our adjudication law is common across the border, and the English courts naturally have a larger number of disputes and appeals than we have here in Scotland. And so key lessons and the likely future approach of the Scottish courts can still be learned from all of these cases, and that's why it's important that we look at these today.
So we'll begin with Deluxe Art and Theme Limited against Beck Interiors Limited. The factual background of the case is that Beck, the main contractor, engaged Deluxe as a subcontractor to supply and install joinery items in the Lanesborough Hotel at Hyde Park Corner in London. In July 2015, Deluxe commenced an adjudication for variations and acceleration costs. Then, in October 2015, Deluxe commenced a second adjudication in respect of extensions of time and loss and expense. Then again in November 2015, but crucially whilst the second adjudication was ongoing, Deluxe referred a third adjudication to the same adjudicator that was involved in the first two adjudications. The third adjudication concerned the failure of Beck to reduce the rate of retention from 5% to 2.5% upon practical completion of the subcontract works. The adjudicator decided in favour of Deluxe in all three adjudications, and Deluxe thereafter sought to enforce the decisions of adjudications 2 and 3. Beck resisted the application on the basis that, pursuant to paragraph 8(1) of the scheme for construction contracts, without the consent of the parties, the same adjudicator could not adjudicate on more than one dispute at the same time. Paragraph 8(1) of the scheme says the adjudicator may, with the consent of all the parties to those disputes, adjudicate at the same time and more than one dispute under the same contract. The wording here in the English scheme is identical to that we use in the Scottish scheme for construction contracts. In coming to the decision, the judge had to first consider whether the adjudications, this is the second and third adjudications, were part of the same dispute. If they were part of the same dispute, Beck's argument would fall away, even if that single dispute had been referred across two adjudications. The judge decided that the adjudication did comprise separate disputes, and he gave consideration to the court doctrine set out in a case Witney Town Council against Beam Construction in 2011, and the court there said that if a disputed claim number 1 cannot be decided without deciding all or parts of disputed claim number 2, this establishes such a clear link and points to there being only one dispute. The judge thought that the extension of time claim in adjudication 2 was capable of being decided without reference to the retention claim in adjudication 3, and therefore the disputes were separate. There were a number of other pointers to these being separate disputes as well. Firstly, Deluxe themselves considered them to be two separate disputes. Secondly, the adjudicator had ruled that the two aspects were distinct. And thirdly, Deluxe referred the claims in two separate adjudication notices which described the disputes in very different terms. As the two disputes were separate, the rule in paragraph 8.1 of the scheme was relevant. The court held that there was a clear requirement under paragraph 8.1 of the scheme from all the parties to agree to the same adjudicator. As Beck had not consented, the adjudicator did not have the necessary jurisdiction to decide the third adjudication, and so the decision in the third adjudication was therefore not enforceable. Deluxe did argue that paragraph 8.1 of the scheme was incompatible with section 108(2)(a) of the 1996 Construction Act, which provides that a party can give notice at any time of his intention to refer a dispute to adjudication. However, the judge held that the scheme was lawful as a restriction on referring one dispute at a time to the same adjudicator without consent did not unreasonably fetter or impinge upon the underlying right to adjudicate at any time. Parties could refer any dispute to adjudication at any time. The restriction in paragraph 8.1 of the scheme only limited the adjudicator who could then hear that dispute. Under the scheme, parties looking to have multiple disputes decided by the same adjudicator will now either have to agree that with all parties or wait until the first adjudication has concluded before referring another to the same adjudicator. From our recent experience, not all adjudicating nominating bodies are alive to this. Many A&Bs have a policy of appointing the same adjudicator to a dispute under the same contract. And of course, this largely makes sense because that adjudicator will have a background understanding of the project and contract. However, again, many A&Bs may not always check whether the first adjudication is finished before appointing the same adjudicator to a second adjudication. So parties do need to be aware of this to avoid either their referred adjudication being unenforceable, or if you're defending an adjudication, to consider such a jurisdictional challenge.
Next, we will look at the case of Sterlite Construction Limited against Croft Contractors, in which there was a claim that the adjudicator's decision was both in breach of natural justice and in excess of his jurisdiction. The facts were that Sterlite engaged Croft to carry out shell and core works, called Phase 1 works, of a substantial house. The contractual completion date was 20th of October 2014, and the contract permitted Sterlite to grant extensions of time for delay caused by relevant events. In August 2015, Sterlite sent a letter of intent in relation to fit-out works at the property, which were to be Phase 2 works. Croft signed the letter of intent, but the parties did not enter into a further contract, and that letter of intent expired in November 2015. At that stage, practical completion of Phase 1 had not yet been achieved, and Sterlite claimed liquidated damages for delay. Sterlite referred the dispute to adjudication. Croft claimed that the delays had been caused by relevant events under the contract, and extensions of time should have been granted, thus negating any liquidated damages. The adjudicator in that case decided that no liquidated damages were due and that a reasonable date for completion was 5th March 2016. Now this was on the basis, he decided, that the time for completion had been set at large because the contract administrator was unable to grant an extension of time under the contract for delay to the works caused by the issue of the letter of intent and the subsequent carrying out of Phase 2 works. Sterlite raised proceedings in court and sought two declarations. The first was that the adjudicator's decision was unenforceable because the adjudicator had breached the rules of natural justice. Here, Sterlite claimed that the adjudicator had decided that time was at large without inviting either party to comment on that possibility. The second declaration sought was that the adjudicator's decision that a reasonable time for completion was 5th March 2016 was unenforceable because it was outside the adjudicator's jurisdiction. With regard to natural justice, the court held that there was no breach. Justice Carr said, "It will be a rare case where there has been a breach of the rules of natural justice. It was clear that the adjudicator had jurisdiction over the question of whether or not time was at large. The authority which formed the basis of the adjudicator's decision on that issue was before the parties, and each did or could have made submissions as they wished. The judge found that the adjudicator reached a decision on a point of importance on the material before him, rather than accepting the submissions of either of the parties, and that this did not amount to a breach of natural justice. He said that the adjudicator had to consider whether time was at large in deciding the extension of time dispute. However, the judge did find that the adjudicator exceeded his jurisdiction, which was the second ground of challenge, and that he'd done so by setting a date for completing the works in a reasonable period. Given that this date would only be relevant to a claim for unliquidated damages, and it only arose because of the finding that time was at large, the adjudicator did not have jurisdiction to make this finding. His jurisdiction was to consider a liquidated damages dispute only. Therefore, this part of the adjudicator's decision, namely where he set a date for completing the works in a reasonable period, that part of his decision was severed from the rest of the decision. Otherwise, the remainder of the adjudicator's decision stood and was enforceable. As the judge notes in this case, it's extremely rare now to have breaches of the rules of natural justice. An adjudicator would have to make significant errors in procedure or approach in order to justify their decision being set aside on this basis. Adjudicators, nevertheless, still have to be mindful of the rules of natural justice, and they need to set the procedure and their approach in compliance with natural justice considerations. Parties in an adjudication also have a responsibility to present relevant submissions, whether asked of them or not, as this case shows.
Now we're going to move on and look at Lulu Construction Limited against Mullally & Co Limited. This is an interesting case. It has been grasped by referring parties in many recent disputes we've seen and held up as a means by which they can claim adjudication costs. And unfortunately, it doesn't do as much for referring parties as many perhaps have thought it does. So in this case, Mullally was the paying party in a contract, and they had actually commenced this adjudication to establish the outstanding payment sum that was due from Mullally to Lulu Construction. So rather than the more usual way round of Lulu would ordinarily have been pursuing that payment. The adjudicator decided that the outstanding payment due was and decided its value, but he also went on to award interest and decided that Mullally should pay Lulu Construction's costs of the adjudication. Mullally paid the outstanding payment that had been found due, but they refused to pay the awarded interest or cost of the adjudication. Lulu Construction sought to enforce this unpaid portion of the adjudicator's decision. Mullally resisted enforcement on the basis that Lulu Construction had not originally claimed such a relief in the adjudication, therefore saying it was not part of the dispute before the adjudicator. Mullally argued, therefore, that the adjudicator simply did not have jurisdiction to make those awards. The court disagreed with Mullally it decided that the adjudicator did have jurisdiction to award such a relief to Lulu Construction. The court did acknowledge that the interest and costs were not part of the dispute which had originally been referred to adjudication by Mullally. Lulu Construction raised the claims for interest and costs in the adjudication, albeit belatedly. However, in the circumstances, are very peculiar to this situation, being that the paying party, Mullally, had commenced the adjudication to establish the outstanding sum that they had to pay to Lulu Construction, it was reasonable, the court said, for an interest and costs claim to be brought in to the dispute through Lulu Construction's defences, and therefore to be part of the same dispute, and therefore within the adjudicator's jurisdiction. And the court said that a reference to arbitration or adjudication may unavoidably be widened by the nature of the defence or defences put forward by the defending party, and also that a dispute referred to adjudication will or may include claims for relief which are consequential upon and incidental to it, and which enable to the dispute effectively to be resolved. So in essence, the court said, just because this has come in through a defence doesn't mean that it can't be part of the same dispute. As I said at the start, we have seen this case give rise to a flurry of adjudications attempting to claim adjudication costs using Mullally as justification. However, first of all, Mullally was just simply an adjudication enforcement case. The court did not decide whether the adjudicator was right to award the other party's adjudication costs, only that such an award was within his jurisdiction. Now, we don't think the adjudicator was right, or that claims for adjudication costs would necessarily stand up to full judicial scrutiny. So, on this point, the use of Mullally as justification for claiming adjudication costs, the point is simply to be aware that Mullally is being used extensively and probably incorrectly to justify adjudication costs claims.
Next, we'll look at AMD Environmental Limited against Cumberland Construction Company Limited. This was an adjudication enforcement case in which two issues were raised. The first was the alleged absence of a crystallised dispute at the time of the notice of adjudication, and the second was the failure of the adjudicator to address the matters at issue. The adjudicator rejected the no dispute challenge, noting that there had been a 5-month gap between the application for payment on 31st of March 2015 and the notice of adjudication being raised on 2nd of September 2015. Mr. Justice Coulson in the TCC agreed, noting that he had observed previously that, in quotes, this argument is frequently advanced and almost as frequently rejected by the courts. This argument is a reference to the argument that a dispute had not crystallised at the time of the adjudication starting. The defendants in that case said that they had been asking for information on parts of AMD's claim, but that AMD was not always forthcoming. The judge here said that he considered it was wrong in principle to suggest that a dispute had not arisen until every last particular of every last element of the claim had been provided. When the adjudicator had ruled that there was a crystallised dispute, Cumberland had that same day requested an extension of time to serve its response to the referral notice. In a subsequent communication, Cumberland expressly acknowledged the adjudicator's decision, quotes, to overrule our barrister's objections to an adjudication, close quotes, without reserving Cumberland's right to challenge the decision subsequently on the same ground. And on that basis, namely the absence of a reservation of its position, the court decided that Cumberland had impliedly accepted the adjudicator's ruling on jurisdiction, and that they were treating him as having the necessary jurisdiction, therefore, to proceed. Cumberland also suggested that the adjudicator's request for further information during the adjudication and AMD's compliance with that request constituted a breach of natural justice. The judge rejected that submission on the basis it was made, namely that it was somehow unfair if the adjudicator was given information during the adjudication which had not previously been available, whether or not it had been previously requested. What the judge said was that if an adjudicator asks for more information during the adjudication, it was obviously wise for the claiming party to provide that information, regardless of their own view as to its materiality. It would be contrary to the scheme for construction contracts and the basic principles of adjudication, the judge said, not to allow the adjudicator a wide discretion to seek information that he or she believed to be important. Finally, of note in this case, AMD sought interest at 8.5% in terms of the Late Payment of Commercial Debts Interest Act 1998. Cumberland suggested 2.5%. However, the judge decided that the right figure in this case was 6%, and he said, "That is because this adjudication decision should have been honoured some time ago, and the arguments in support of the defendant's position were properly characterised as hopeless. The TCC is concerned that too many adjudication decisions are not being complied with, and that there are too many disputed enforcements where the grounds of challenge are without merit. Thus, a high interest rate under the Act will be awarded in such cases."
Our last case we will look at today is John Siskins Son Limited against Duro Felguera UK Limited. This is another adjudication enforcement case. Sisk sought to enforce a decision which awarded it a sum in excess of £10 million. Duro resisted this on the ground that there were breaches of natural justice. Duro's argument was threefold. Firstly, that the adjudicator had approached certain issues with a closed mind. Secondly, that the adjudicator appeared to have delegated certain parts of his decision-making role to a third party without notifying the parties or seeking consent. And lastly, the adjudicator had tried to rectify or amend the contract where neither party had submitted it should be rectified, and without giving the parties notice of his intention to do so. The first issue related to Duro having raised challenges to the adjudicator's jurisdiction at the beginning of the adjudication process. The adjudicator had issued a non-binding decision that he had jurisdiction, and then went on to set an agenda for the rest of the proceedings. One of the first steps in that procedure was for submissions from the parties on the jurisdiction issue. The court had to decide whether, because of the early jurisdictional challenge, the adjudicator had approached the dispute with a closed mind. The judge ultimately determined that this challenge failed because, amongst other things, the adjudicator had given the parties an opportunity to make further submissions on his determination of jurisdiction, demonstrating his open-mindedness. The second issue involved the delegation of responsibilities by the adjudicator to Mr. Hutchinson, who was a quantity surveyor and qualified lawyer. Mr. Hutchinson, the adjudicator's assistant, was present at one of the meetings of the adjudication in relation to quantum. The adjudicator stated in the court that Mr. Hutchinson took notes on the day of the meeting and had done other certain things of checking and researching into matters that he, the adjudicator, had directed. Duro's concerns were raised when several of the spreadsheets attached to the judgment by the adjudicator were found to have been created by this Mr. Hutchinson. However, the judge ruled that the documents were consistent with the adjudicator's explanation that Mr. Hutchinson's role was purely administrative. The court agreed that the adjudicator's task in this adjudication would likely have been impossible without administrative assistance, and therefore accepted the adjudicator's explanation as to Mr. Hutchinson's role. This case is definitely a marker that the courts are increasingly perhaps frustrated and certainly reluctant to obstruct adjudication decisions and to enforce adjudication decisions, and that they are raising the bar as to the arguments that will need to be successfully put forward in order to make such natural justice and jurisdictional challenges. The onus certainly rests with the objector to demonstrate bias and breaches of natural justice, which, as we've seen in this case, is not always going to be easy.
So, what can we take away from these cases today? Well, firstly, they highlight the importance of keeping up to date with case law. For those of us practicing in the construction industry, the law is fast moving and constantly changing, and it's very important to stay alive to these changes. Because if you do, then it puts you at an advantage either by being able to make new arguments in adjudications or to take advantage of new case guidance in the arguments that you put forward, or it enables you to react appropriately and promptly when such arguments are raised by the other side, and for example, by appropriate use of jurisdictional challenges if they occur. It's not uncommon for several adjudications to arise from one contract in our experience, and often in the past the same adjudicator has been used to decide the separate disputes for good reasons of economy and efficiency. But it's clear now, given the case law we've spoken about, that should multiple disputes arise at the same time, consent will be required from all parties to the use of the same adjudicator in more than one dispute. That's clearly a disadvantage, because when one gets into the situation of a dispute, then getting agreement of all parties can become a difficulty. If consent from all parties is not achievable, then the claiming or referring party will need to wait until the first dispute has been considered and decided before referring another dispute to adjudication, or alternatively, to have a different adjudicator decide that separate dispute. Also, as we've seen, the courts are continuing to demonstrate that resisting enforcement of an adjudicator's decision based on a breach of natural justice is limited to very rare circumstances, and it seems to us that an adjudicator's approach and procedures would need to be quite extreme for such a challenge to be successful. Decisions being overturned due to jurisdictional challenges are perhaps a little more fertile ground for success. A common jurisdictional challenge is there not being a crystallised dispute. Now that's one that we have seen very rarely upheld, but there are other jurisdictional challenges which are not based on natural justice breaches, which are continuing to succeed, albeit in a limited number of cases. Okay, so that ends our webinar. We hope that you've enjoyed this and found it useful. We do have a few minutes to answer any questions that you have, so please feel free to type them into the chat screen now if you wish to. Don't forget that you can listen again to these webinars or share them with colleagues via the recorded versions on our Vimeo site. And also I'd like to mention that our next breakfast seminars will be taking place in Edinburgh and Glasgow on the 21st and 23rd of March. So if you'd like any details for those, please let us know. At those seminars, we will be looking at current issues affecting the construction industry, and it would be great if we can see some of you there to exchange views and experiences. Our breakfast seminars are valuable from a knowledge update perspective, but they also offer networking opportunities. Okay, so I think we just have one question which we've time for. So the question is just a general question: do we think that adjudication is a good process, and do we see it continuing in the construction industry? Just to answer that, I think there's no doubt that adjudication has been a success in the construction industry. That's one of the reasons why it's used so much, because there is a lot of adjudication around at the moment. The reason it's been a success is that it has provided a means of getting disputes resolved in a much quicker time than was available in previous times, when parties had to rely on arbitration and court, which take quite a long time. I think, though, the process has evolved into something which perhaps it wasn't intended to be. In particular, it's now covering very large and complex disputes, and all of that it's supposed to deal with in a period of 28 days. In our experiences, that rarely happens now. So it may be that at some future point in time there will be a similar review of the process as was done in 2009 when the original Housing Grants Act was amended. So there might be circumstances whereby the process could be altered. And I think one of the key aspects at the moment is the variable quality of adjudicators' decisions, because as we heard in one case, the court, the TCC particularly, is observing how often now adjudicated decisions are being defended at enforcement, sometimes on hopeless grounds. And I think probably that's a result of the number of occasions now where adjudicated decisions are of variable quality, and parties are just trying to find a way of frustrating those decisions because they just believe them to be incorrect. So it may be that perhaps the focus on the process in future should be on adjudicators receiving the necessary training. But I mean, I think that's something that we're likely to see happen as a result of a future review of the process. But I think in summary, it is generally a good thing for the industry, and it's definitely here to stay. And the only qualification to that is I think there's likely to be another review perhaps in the next 3, 4, 5 years' time, and there may be some tinkering with it, but I think in the longer term it's here to stay. So that's our only question. So I'll just say thanks very much indeed for listening to us. We hope you found this webinar and the previous one helpful. We look forward to welcoming you to our next webinars and seminars, and we'll circulate details of those in the future. So thanks very much for listening to us.